Hi, everybody. Welcome to our April episode of our KML Foundation Table Talk vlog. I'm happy again to come to you with another episode, and today we're talking about something, quite honestly, until I was in this position, I had never heard of. We're talking about TODs and PODs. But what exactly does that mean? Well, today I've got a special guest, attorney Andy Felkowski, and we'll learn a little bit more about these two instruments and to see if they're right for you. So as we talk about TODs and PODs, I'm welcomed by attorney Andy Felkowski. Andy, welcome.
Hello, Paul. Thanks for having me.
Let's just start with, the very simple explanation. What is a POD and a TOD?
Sure. They're basically just simple letters for that mean transfer on death, TOD, or payable on death, and they're designations that can be used at banks and financial institutions to control your money.
So control your money. So you said banks and financial institutions. Does one apply more to banks and the other one to financial institutions?
Absolutely. The POD designation is generally affiliated with banks. So think of your checking account, your savings account, maybe a CD. TOD is generally affiliated with securities, so like your brokerage account, things of that nature, maybe a stock, something like that. So those are the general designations where they are used.
Okay. Now, as I said in the beginning, I don't know if I heard about these before. Why is this not well known?
Sure. I don't have a perfect answer for you, but in just doing a little bit of looking, it appears the POD statute came in around 1989. Then there's another document known as a TOD deed, which we'll cover a little later, and that covers real estate. That came in 2006. So I don't think they're the newest, or they're a little bit newer devices. And then the second reason is I think estate planners are aware of them. We do use them. They're one of our tools in our toolbox, but we're a little cautious, and they don't always fit in every situation. So I think estate planners may be a little more comfortable using wills and trusts, where these are they fit in certain situations, but not in every situation.
It sounds like there's some issues there that we should probably talk about. But let's start first of all, again, maybe a little bit more basic. So what is the actual process for creating one of these?
Sure. So it could be as simple as going to your local bank where you have your checking account, asking the bank teller or manager for a POD designation form. You then fill in that form. They witness you, and then they keep a record of that in your system, in their banking system. And so upon your passing, that account will automatically go to the beneficiary or beneficiaries you named on that document. There will be no probate. There will be no lawyer needed. It just happens by law. And so so the simplicity is nice, but of course with simplicity there comes some other questions and issues which we can cover. But the document is simply done at your bank or financial institution. They have the forms. So lawyers do not have forms to set up a POD or TOD for a bank account. That would be done at your local bank or a brokerage account.
Okay. Is there a cost for people to do this?
For doing them at your bank or brokerage account, my understanding is there is no cost. So that is obviously one of the factors clients would like, is to say, hey, I can do an estate plan without having to call my estate planning attorney. But through the banks, they would be free, I believe. Now, there is a unique one I'm going to mention called the TOD deed. That's for real estate. So if you have a house or you have a condo, and you would want to avoid probate, and you met with your estate planning lawyer, that's one of the menu items we would discuss. And every attorney and law firm is different on price, but for example, those are usually in the $300 to $500 range or something like that. And then there is a $30 recording fee at the Register of Deeds. The deed is actually recorded, but you still control your house. You still own your house. So upon your death, that's when it would automatically transfer over to the named beneficiaries on the TOD deed.
Wonderful. Now, Andy, I've got to say, it's free. It's easy. You avoid probate. This doesn't happen until you die, so you're not relinquishing any control during your life. This sounds pretty good, but I'm guessing you're going to say there are a few concerns.
Right, and you've got it, Paul. And we deal with this every day, and I understand why clients would be enticed to listen and to want to know more about PODs and TODs, and they should. I will kind of give a few examples. One to think about would be if you have an existing estate plan, you paid an attorney, you have a will, you have a trust. 7 years later, you stop at the bank and you maybe talk to a bank teller, a manager, or a broker, and they say, hey, we got this hot new thing, POD, TOD, and your kids, when you die, they don't even need a lawyer. They can come right in, grab the money. I mean, it is great. And then the lawyer says, but there's a few things. Number one, if you have an estate plan and you set up a POD or TOD, that POD or TOD trumps your estate plan. Mm-hmm. Okay? Second issue would be who's in charge. So let's say you have 4 kids and you have a POD account and you name all 4 kids on the account. At the bank's going to hand them 4 checks. Well, who's going to handle the house? Who's going to pay for the funeral bill? Who's going to pay the homeowner's insurance while the house is being sold? So it's I kind of refer to it as parking lot law. So if the 4 kids can all get along and all work everything out on their own in the parking lot, it will work great. If they can't, you're going to have some issues. And I've seen those issues in my practice. I've seen people say, Mom named me as POD. She likes me more than my brothers and sisters. I'm not sharing this money. Sure. And legally, she is in the proper position. And that can get very awkward with family situations. So the big thing about wills and trusts, I would say, is you're naming a person or persons to be in charge. There's a boss. There's a person who will collect the money, pay the bills, handle all the affairs, personal property, cars, all the unique items. And then in the end, they are required to do an accounting to show what they had, what they did, and hand out the shares at that time. So it's a little more organized, where the other one's a little more parking lot, right. Is what I describe it as.
And you mentioned something unfortunate but true, that parents, I think, want to believe that their children will all get along and do this properly, and and some cases that's true. I guess I've seen too many situations, and I know you've seen way more, where that doesn't always happen the way the parents would like. And so in spite of, it's not I don't trust my kids, it's more let's not put the kids at odds unnecessarily. Let's handle this properly. So if I understand correctly, TODs and PODs do have a potential role. How do you recommend putting them into the estate plan? So if you're meeting with a client, you want to put a comprehensive plan together, do you use the PODs and TODs?
Absolutely we do. I will give you just a simplistic example. A person who recently lost their spouse, maybe a widow, comes in, she's got a condo, she's got 3 bank accounts and an IRA. Just a fairly modest or basic estate. And I don't even mean the values. I just mean simple assets. And she says, Andy, I've got my IRA naming my 3 kids. Andy, I went to the bank and I've got a POD designation on those accounts already. I'm all set. What am I going to do with the condo? And that's when I would say, you know what? How old are your kids? Oh, they're all adults. Do they all get along and play nice together? Yes, they do. I would say I think a TOD deed would be a logical situation for you. You don't need the full trappings of a revocable trust. You all of your other assets are already lined up to avoid probate. Why don't I help you do a TOD deed to avoid probate on the condo? And that would work. Mm-hmm. So when I sense simpler assets, adult children, play nice, get along families, I think there's definitely a place for the POD, the TOD, and the TOD deed. But when I sense other things of complexity and family dynamics, how about minor children, special needs children, spendthrifts, people with alcohol or drug problems, PODs and TODs are not a good option, because the moment you die, that person has instant legal access. And a lot of my clients do not want instant legal access to funds upon their death.
Right, and that again makes a lot of sense. I guess this might be too much of a simplistic summary, but I think what happens is a lot of people will think, you know what, I don't like lawyers. I don't want to spend the money. I don't want to spend the time. I don't want to go through that whole legal process. Does that mean I got to go to court and all that other stuff? And so they're trying to find a way, whether it's beneficiary listings, POD, TODs, those kind of things. How can I avoid even seeing the attorney? Because I just don't want to talk to him. And I think the risk of that can be pretty dangerous. Not necessarily for the people making that decision, but their loved ones. So I really can understand what you're saying. It's not that you have an opposition to any of these tools. It's let's use the tools in the best possible way for each situation. Is that too much of a simplistic summary?
No, I think that's spot on. And one other, again, not to be negative, one other thing I'll just mention is when you fill in those forms at the bank and you name the 3 kids, if, let's say, son John would pass away and you forget to go in and update those designations, those designations generally do not have contingency planning in them. So technically, John's heirs or his children may not get a third of that account because the banks don't have contingency planning, where the will and the trust plan do say what happens if John dies. And if John had young kids, we can hold the money back till they turn 25 to pay for their college and etc. So it's the contingency planning also that I'm always worried about. So I do use them. I do believe in them. They are a good tool at times, but I always want to caution my clients that just think this through a little bit. And a lot of times the clients say, okay, that made sense. I kind of understand why maybe a will or a trust might work in my situation.
Sure. One more thing that I often tell people is that you don't necessarily have to update all your documents, but you certainly review them. I would say at least once a year. And that kind of thing exactly, the POD, TOD, a beneficiary listing, that kind of thing. You forgot, oops, I named my ex-wife and I never changed it. That happens. You think, that would never happen to me. Trust me, it happens. Review your documents every year, and if you don't have somewhere written about that POD and TOD, you better make a note for yourself to make sure that those are still current. Andy, is there anything you want to add?
No, I think we really covered everything well, and I appreciate you having me today, Paul.
Oh, thanks for coming. When you start talking about all these different tools that are available, PODs and TODs can be a very valuable tool for you. And maybe something you didn't know about before, and we hope that this vlog was able to maybe educate you a little bit. But I think Attorney Falkowski was pretty wise here in saying, don't think of them as your sole way of being able to plan appropriately for your estate plan. They are one tool, and they might be good for you. Talk to an estate planning attorney to make sure that it's really the right way to go. So thank you. Again, we do this because it's your life. It's your plan, and it's your legacy. And we'll see you next month.